ebi ho no ma no wadi kan ware obi foforo e wo mmerem na sa akware obi e foforo so a sa awade na wo ware second one no enim ana say parties ne ba akwa ware deda e no wo sa bebe ware obi ordinance marriage we nyefia ware ya maami Akosua Serwaa na ware no o ware that Lumba no say o ware no e wo civil registry wo Germany na ware no e monogamous na just e ba ko oba ba ko be ma ba ko ware na say baba ko be ma ware ba ko ware a aware no mugu no anaso omo ngu no ansa na that Lumba. Oh, this is very crucial. Wow, but there was a winner judgment bi akobi pe 23 e ho ne hwe the at the crontia o ka say crucial is sense ya maami Akosua Serwaa say oni that Lumba ware under ordinance and a civil marriage e wo Germany. It was say crucial say ye be hu sankrata asemi e wo asemi a ye ba be bua mu enti ase ye san say sa asemi abapen na krata yi emre bi a wo mo koma injunction so mo ka injunction no mo file in October no oh mo kai injunction no mo man so October no 28 October 2025 no sakrata akro ya o jaje na ka wa ha o Ose sakrata akro ya ene ye dia ba abra ye tie substantive case no injunction ni mu e baaye injunction ni mu krata ya mo de baaye e ba so say asem na mo ka no ana krata na mo de aba no endimu enti se mo pese mo de ba ha de a wonim de wo beye me what I say ose me kire ne say safa kone koye ne ai wo se wo de ye ansa na wasa de aba enti ye me nwanwa okay was na make over ubetimi aka ya ka mpeja nchiro
abuja nchawo me ba cho unim se maami Akosua Serwaa appeal a wo ye no e wo Kumasi court case no enche court betan so no so o master te ho nsem kan na say bibi atimi akoni ehu de ebeko but I chanced on this video from a lady bia or TikTok and credit to her me leave ne handle e wo video ne so na ubetimi akocheck ne apa nyame adom onya a 48 page court ruling na judge no e de babonti anase court ne de babonti and based on that Kumasi High Court ema da ruling na ekwoti maami Akosua Serwaa a wo de kwaya appeal no now what lady ni breakdown na wutie court ruling na in fact I am tempted to believe say judge now oma ruling no I say oma aponi nyina and you say maami Akosua Serwaa lawyers they go by that apona judge no Kumasi ne de mind na it is possible say something positive will come out from the appeal no mobeko no. The only issue I'm listening to that and they say I feel like maami Akosua Serwaa lawyers omu feeling no because according to this ruling na maami we breaking it down obitin ebeko kotie no judge no is titi niema enko obegina so e de ruling case na nke beko another angle which the plaintiff which is maami Akosua Serwaa the lawyers omu failure to provide. In fact, interestingly, judge na ankasa at one point in the ruling before so obema the final verdict no ochemu say wonim say case in chance and there was a time injunction bi ebetwam judge ni chemu at the time injunction e buy a omu breaki assembly kakra for be 1 month no wo kire wo which is Akosua Serwaa lawyers no enema bi a omu nkonko ya ebema omu nsem no edimu. Now this video about Besha Mami we Emma breakdown. According to the breakdown, going by the judge and some say obi ware under ordinance ewo Germany Ghana mra ejitum except say our begu our ngu ya Ghana mra ejitum and under ordinance no untimi ware obi foforo bi abiem. So in this case say mutimi provide and I say mutimi prove pan say indeed ya ware under ordinance or Germany then automatically Lumba's married to Obebia ewo Ghana and I say any other country bia no because of the German law na binding ninti no I cancel sa aware no but the only thing I may feel say nanka judge na hwehwe I betimi ama a ruling in favor of maami Akosua Serwaa was certain conditions bia na say the lawyers need to me boa emo for failing. Now enu bi when a judge ni chim say enkohwehwe niema bi which is the expert witness which is that esen komutimi ni obi a oti German emra ye no ma ware emra ase nanka bi oba be di abanse e wo court ho e convince judge ni say indeed German wale mu no saying a near mate, and according to that German warrior remuno, ultimate worry will be for. And at that point alone, and Kaja didn't me, I convinced indeed, Odo Broni warrior no, or better on the fire, and I said, or better cancel, Nanko, Mamma Cosas, or beat me away the case. No. Aside that, now, Judge say, although say, when the certificate be abam, certificate no, your conditions be a one, as for failing. Sasa conditions no more intimi anya all those certificate ni kutawo judge ni so yi ne judge ntade gu nchen na ofri court ho a obetimi hu say indeed we your marriage certificate all right, but the moment obe assuming the role of a judge na esase o camera ni ntino ontimi mfo no ankasa ne conscience any emotions enka say because me as a judge me hu sampa we marriage certificate free Germany into automatically be jetu enema bi wo ho nhyehyɛ bi wo ho a na say lawyers for Mammy Akosua say one committee for failure or mu failure wo ho. And those are the reasons why say we make yes sir. Although say a bed ni party be more humanly, the human side of things. Judge ni hu nso wade we say net but emra e kire say enema bi say ka ho ma amfa ama. It is a man fa sa ne ma na nka ho dia. Judge ni ntimi nka say because we nipa and we judge into automatically obu ama mo. Because si e ka so bi e mampani example ni say yenim say president Mahama ye mampani but ye woni ma bi say ka ho na prove say indeed we ye mampani wo court enya sa won timra me gina me ka say we mampani nko aheke ne age atum. Those were the things I feel like Mami Akosua say wa lawyers o mo ntimi amfa anko, and to me I feel say Mami Akosua say wa lawyers going by this sa video e ba beti no o mo faili maame no and say appeal we o mo kono so mo timi eye de Kumase court judge ne kan ye na. Because I feel like Kumase court judge no technically that really never to mba beti no e ya apo na nkasa no de ma wo apo no dot munko ye wi I say teacher ni ama exams na wakotwere no wa feel wa mark so wati but e ha kotwere we hye ho wa anko ye na wo sa de ba obeti wu, and be able to go and do that homework now appeal no there is a higher chance say there will be positive news for team legal wives and Mami Akosua say wa abusiame nche ho yenko na yentie nsem no point by point. In fact this video o share with judge na o explaining according to Ghana mrem aware miensa, which is the Islamic law, Islamic marriage, the ordinance marriage and the customary. But then ebia no ebeba say judge begimi ebetimi ajetu anasa court bejetu amana di mrem no ebeba in connection with amamre any a bit of omicron emra. Those are the three marriage marriage processes and answer marriage types are your war Ghana marriage too. But then say ultimately be can prove, because now video baby there is a point out there Jenebeka say about court they were able to come up with pictures of Akosua Serwaa any Lumba. Yes, no more sign. Bibia, it is supposed to be a marriage document or a marriage certificate. However, they couldn't provide the original certificate now you're signing. Aside that, judge say, even you say on the original certificate ne buyer, Ghana mremu, and judge no Ghana mremu ne chere say, yes, what they call Ghanaian embassy or Germany. Now, a translation, no, ebia, according to German Mrano. And she said, "Ni bibiano, embrem legal terms or Germany chisi, but it's all translated by Ghana for side, na Ghana what you say. Na Ghanaian embassy or Germany, et me certify, authenticate, say indeed, you translating and translation, we know, a bag Ghana mrema ye jutum, and sign and commit media about court. Jet lawyers man, yes, I man. And these are the things that if failing Mami Akosua Serwaa, court, a man judge man really. So, utie video na pay attention. Now, judge non kasa no, you could tell say, as a conscience wise, like common sense money or side with Akosua Serwaa, as a onimnie maybe, what I say, wajini maybe too. But then because of emrati training incentive, only mean based on emotions, as a conditions a can be aneba, and sana and judge me really otherwise. But then Sani Manamba, and personally to me, I feel like Mami Akosua Serwaa and the lawyers, they did, I shouldn't say a lazy work, but I feel like Oma Heda and going forward in the appeal, no, we expect say sa homework no sa upon na judge ndi ama nyina no on betimi a work on that, and that could turn things in favor of Mami Akosua. We say yentie nsem no say the course so e wo court so
e wo page 22 na page 22 e ho no na Yenera Dorinda Arthur Okasafa approving a valid marriage. And say, wo chere say wawariye edim anase wawariye e wo mremu no edim. Aha. Na ho no mo no start say the primary and direct proof of a valid ordinance marriage is the performance of the marriage. That is say, answer na wa betimi a chere say wawariye edim no na e wo say awariye no kra abaso. Say de ehun say bia wa ya yefro. What na say no. Any the first one. Na wo wi a e was a wunya documents a back case performance no enti anya se wa hihye nkonwa wa frɛ ya ba ma chese masensan bibi na ye hu krata bia na no chese wa ware enti o say a combination of other documents corroborating the performance of the marriage is more convincing than a single document. So as I say akofa wedding invitation ba enti o krata ni e was say hu ya so wie na oba beka say e wo ye wo eniema bia enye it may not be enough to prove marriage. Example, or say ye wo emre bia marriage certificate nko a entimi nkyere say aware dimu ana say ndim. Eniema na bia marriage certificate nko a entimi nkyere say aware dimu no. Ene obibo obi any non consummation say nipa mienu makoye court aware na emu mienu munhia wo namuda. Munhia wo namuda. Ye hia maware so ma mo wie munhia wo namuda. Eno ekyesa maware enim. Osi in fact osi nullify na chese aware no kure ni ho na nka pesa abedimu ana endim and nullify no completely. No osi mental incapacity of a spouse e bia na wo ware no na nipa kro na adwen no ho enhyeda anye okay kakra eno so na chese nipa kro no need the menstrual betimi a consent say aware no wo peneso ana wo peneso ntia no so e ma aware no enye dey enim e bi wo also osi cases of fraud and na e bi so issues with certificates na nkasa osi e bi also aware no kra no efiri ahyase na chese egu ahyase na enim void ab issue na chese aware no hyase na aware no enya aware papa na say egu mpo abraham hyase nti muko kra na mu consummate kra aware na enya papa eno no work ye no say e bi ho no ma no wedi kan aware obi foforo e wo mmerem na say akoware obi e foforo so a sa aware na wo ware second one no enim na fraud sa wo koye bia mi ti he na midin na e bia midin dia so mesi na makwa che ni pakwa ne se midin dia obenti na me de no akwa ya ware no a eno no sa ware ni me san se midin kura anya no kore e be dan ware na ye den awo enti wo kan no wie no refer to section 46 of cap 127 the Marriages Act 1884 to 1985 no or refer to no say sa so na say wo convert wo fi aware o convert wo fi aware e ko ordinance mu a wontimi ware obi foforo nka wo kai se me kan wo back ni sa wo sa kan wo ha no say aside the say wo munhia wo namu da na niema we mosusu betimi ama aware no enimu kura na say be ye annulled na chese annulled na chese aware na ama so abaso de na emu nimu wo mbrem nti no ye begu no ene say enipa minu no mo ware ni nyina ye mofra Ghana ha yakasa obi abranches wedi below 18 nti no sa nkura ware enim anase parties ne ba akwa ware deda eno wasa bebe ware obi ordinance marriage we nyefia ware wanhwe ba akọ na akọhwe me cheche mu ho spouse ne ba akọ ye force na chese nya ne pe na ode ba ware enim omo che ne kente no de ode ba ware enim ena evidence of deceit and fraud no so maka ho asem wo wie ye no ena oba se ebia na oba ne so se oba ne so nyemma be ma fofora sa ware no endim na instance anuanu mienu amo ware no so what's the list na nya exhaustive betimi akeka ne ma bebre na with any of the above conditions or say when any of the above conditions prevail the marriage certificate alone na say sa ne ma we nyina e wo ho no mo a marriage certificate ne nko a entimi ma ware ne ndim. So the fact that we create my certificate na sasa na ma we mo bia wo mu a aware ne ntimi ndim emfa ho na o certificate ayede e kura wo wie no honom no stay o ma no bibia atwa no de yabo so amam o ma mo a decided case and Estina Boatin versus Serwaa and two others I call civil appeal and 2021 ya enche entu hwehwe a wo be hu into owie ye no oba na o say afede wo sa ba asem na o say I now return to the first issue a wo busa say ya mami Akosua Serwaa na ware no o ware da Lumba no say o ware no e wo civil registry wo Germany na ware no e monogamous na just one e baako oba baako be ma baako ware na say ba baako be ma ware baako ware a ware no mugu no anaso o mo ngu no ansa na da Lumba oh nti owie na ho na obehya ase no say aha say plaintiff, so okay plaintiff no one kaya kono kwe. Mami Akosua Serwaa. The plaintiff is required. There was a plaintiff no what chere. Okay say make sufficient. Make ka brofo na make ka say sa brofo no twetwe ni nyina no. Mmara mu brofo nti enjoy hu sufficient say aduane no so sufficient we say sufficient mmara mu. Sufficient. Properly authentic documents which are not contradictory and legally valid in Ghana as proof of a civil marriage to the late Dadu Lumba. Sa brofo no ma chichirim. Kono kwe. So I say this is very crucial. I say sa adewe. And when here pa into what try I say this is very crucial. Wow. But there was a winner judgment be akobie page 23. I say this is very crucial. It's an say warrior ba ko pe na wo warrior wontimi warrior obi nka ho. Eno ni monogamous marriage and I say ordinance marriage. Eno no warrior wontimi warrior obi enka ho. Yes ape watomra. Into say sa adewe the adikronti oka say crucial is sense say Mami Akosua say wase oni Dadu Lumba ware under ordinance and a civil marriage e wo Germany it was say crucial say ye be hu sankrata asemi e wa asemi a ye ba be bua mu to we no say the lawful attorney some nyam kai de akere mo the lawful attorney o akere mo the lawful attorney ya Mami gina ni obi gina mu di adanse ya Mami Akosua say one wono o say wo kasa no and as in some trial with the buy the paragraph 5, 6, and 12. No oka say na Mami Akosua Serwaa any Dadu Lumba omu ware 23rd day of December 2004 e Germany mrem na odsa so de ho krata e buy no wie no oka say Mami Akosua Serwaa kan on statement of claim paragraph 2 and also kasa. So see the first point I no person was ascertaining the determination of the applicable foreign law. E was same way nyina mu no. E evidence a plaintiff ne de ba say na wade no omo je e wo Germany. And I say omo e contracted under the German law. Nti ho no state section 1 of the Evidence Act. Okay, Evidence Act. We bo chere mu Ghana Evidence Act 323. State who provides as follows said the determination the determination of the law of an organization of states to the extent that such law is not part of the law of Ghana. And that is a emra ini Ghana mremuno emra ini Ghana mremuno or of the law of a foreign country. O man for froso mbrano. O man for froso mbrano. A question of fact. Not to say someone a question of fact. It's a question of fact. But it shall be determined by court. Someone a wo name court ne be bua say it sa na say ntisa. Into we no say the determination 3 no say 1 2 near kan into 1 3 of Act 323 no e one order switch name. So say the determination whether a party has met the burden of providing evidence on a particular issue is a question of law to be determined by the court. Into say wetimi I show where one krata asem amane dimu no eye mrasem enye me say yes eye mrasem enti no so na a question of law a court no na betimi determine and so betimi abua e wo mrem o guys say ye ka Evidence Act no enti ye to aswe free ho enti o wie no say e wo court e wo kuro bia so anase wo man bia so no ya assume say court bia nim ne man so mra ya me ka say enti court bia onim ne mra so mra enti ne man ne Ghana onim Ghana man mra enti no obetimi a apply ne local law anase ne man mra na the foreign law need they operate as a question of fact and not as a law. So what I say nti wo mra na ode ba no e fact mame enya mra mame enti no o de ba me de say de mebu asem mebu na o me Ghana mrem. So what I say I want to show my case into we no say this is to state that a foreign law must be proven by the party usually through an expert witness. No e won ya me pa I was here to see yes and say nsem na waka bebre no sansem waka wa he e ya sem hia o say so wo de mra a e free o man foforo so ba e wo say wo a wo de sa mra no ba wo kire court nim na kwan be na be fa so kire court nim ye free e be expert witness ni obi a onim asem na ye ka no onim mu anasa woti ase no wo mu nyina ye o bi o mu certificate o mu nkrata e chese asemi ameka ho asemi e fa ne se make pencil you want me hu pencil ye na me hu se pencil ye ni say so what I say inti expert witness obi a woni made na expert ye ka expert as what I say inti expert na witness e na yaka bo mu aye na mera word expert witness inti no sa expert witness no e wo so no e be kasa e fa sa ade no ho It must be proven through an expert witness, and a judge is not expected to automatically take judicial notice. You can judicial notice, and that is a be a judge in Wonim. You can say be a judge in Wonim. Say, John Mahama, ye man penny, a Wagana, a judicial notice, Yenina, Yenimunti, judge, and it's a bit me a judge to Musuni. Then, means me, can't judge say, a foreign law, a judicial notice, and I was saying, also wedding, whom the Santino. What's with the expert witness, Ebba, Nasa witness, no, or Becca Safa, 7 home. Now, Crata, now, Debano. Judge need to meet us here. I was some branding. No to me, a day, a buasem no, a one quine so. Into we no sin a sense, I was here, my Akosua Serwaa. What should I say? One only that the Lumba, or more no cremu, a one bremu or Germany. Emma, Intina was what far expert witness, so a children as I did. In the expert witness, or my example said it could have been a qualified legal practitioner, and I say academician will be a child about German or warrior. Ewo so ebia tis o ebetimi ayobia an expert witness can be anybody or kasa wa say owie no ka say or stated the case of Godka Group versus PS International, and also a Ghana case 1999 to 2000. Also the general principle has been that no person is a competent witness unless he is a practicing lawyer in the particular legal system in question, or unless he occupies a position or follows a calling in which he must necessarily acquire a practical working knowledge of the foreign law. And then I'm the church and say, what's any panel or senior or become once and say, and I say, yeah, dear, what dear Juma. And into now, I am running to know, or more as a lawyer, and he said, lawyer need ye, a dear, dear Juma, dear Emra. It is a lawyer needing the German Raya Juma, bet me a church German room. Into Quilbisano, okay. It is also required that a foreign law must be proved afresh. Enti no yamfa say asem ya be say yetimi cheche German mmeremu yi a no nkyere say wo nya asem asa nkyere mu na obegina so da bi o wo be say prove ni bi esan say etimi sesa Ghana emretwam mu nim say emretwam enti no say emre na twam wo ho no ma yehu age say wo na abebo court na mane through your expert witness say emra no etwam e ho no state the case of Serwaa versus Gariba Hashmiu mo guys that same way no mo nkai same way in 2021 trying to hope no a hono na Justice Kulendi or can't say a hono Justice Kulendi refer to section 136 of the Evidence Act. Evidence Act there was a say about this 323 no on authentication hono say where the relevancy of evidence depends upon its authenticity or identity, so that authentication or identification is required as a condition precedent to admission. Inti sa okrata na wode ba no eye ni say enye authentica or say authentication and as identity no eye prerequisite and as precondition say e be authentic enye sa ye nyintumu a ehu hia say wo eye requirement say wo be satisfy evidence no by showing say it is supported what you say and I say edim. It is something, it's a matter of question. I was say we are normal court and transfer court ni be ya no amount. E ho no sa na omo e kire e wa ha. Inti we Justice Kulendi the car in the case of Godka. Inti my lady refer to no we no sa buy no say ha say no the purported extracts omo di free marriage registry ni mo buy no. A foreign document a bear foreign signature. Now, the Evidence Act, this is specifically I provide say a condition precedent for the admission. And I came out to see and said Justice Kulendi can. It was section 136 of Evidence Act anymore. Or see it's a condition precedent. Not just say a idea I was a way ya. Not just say what to watching a cry. So as I say, for admission into 1 year, 1 year. Into was a prove this idea way. Section 136, section 161. So sessions here can in our Cambomoa and no children is a saint cry was a who prove this acratana would be free on my fofroso banner. Now, Sahaso no can say exhibit B no na e was say a year authenticated and a certificate of marriage in a free register of the civil office hobai and also so. Na was say no so a bear some authentication. After that, no say the law mandates that a person takes the certificate. I was any panel certificate no. I quite German embassy. Ghana embassy wa Germany. Emma almost another certification from the head of consulate wo hono before a court no ebetimi ayede ebua asem no. Na all kasa no so no. O say Odo Broni lawyer. Say munna munim D2 say ade munim D2. D2 ye Odo Broni lawyer so. Omo peda akrata no so no. Wo ma asem so. O say there be menti ase. Menti ase esan say. Sa asemi abapen. Na krata yi emre bi a wo mo koma injunction so mo ka injunction no mo file in October no oh mo kai injunction no mo ma so October no 28 October 2025 no sakrata akro ya o judge na ka wa ha o se sakrata akro ya ene ye dia aba abra ye tie substantive case no injunction ni mu e baaye injunction ni mu krata ya mo de baaye eba so say asem na mo ka no ana krata na mo de aba no endimu enti se mo pese mo de ba ha de a wonim de wo beye me what I say o se me kire ne say safa kone koye ne ai wo se wo de ye ansa na wasa de aba enti ye me nwanwa o kan wo se nya na me ka o he wo betimi aka ya ka me mpegya nkire wo betimi aka ya na me mpegya nkire ye ade no o se wo de ma me kan nkire what it is therefore a surprise that the plaintiff did not comply with the requirements nearly a month later. Na make on. See ntia ne nwanwa say edi busumi atwam na plaintiff no wanya nwere kwasa de krata na yeden abre ne sa ne senti no o se kwasa de abre ne sei yede ento aso enti no omo pagya asa krata ne so omo de ba be evidence e ho no na Odo Broni a lawyer no D2 a lawyer so when the medical check D2 o pagya asem ne say there be menti ase e makrata we yenye de yenye nto me san secretary we ye 130 KT ye signature na e wo so no enye ye man mu ha official e signature na e wo so obia so so ntwero krata amfiri ba bi mma mbeka say we etisei expert witness bia so so mbeka san fa sa krata yi hu ne senti me da so gina ne mi gina say krata we entimi anyi ntum wa ha yentimi anyi ntum e wa ha enti no mempere ma court yin ntum na hono na court ne kwakwa ball so secretary ya ba pen ama ho asem ayeden aba ma no kra enti ono kra ne wanwa secretary ya sa aba ne ha ya anya ho hwe ya sa de aba enti na hono no ka say ti any objection a omo pagya e wo secretary yi ho it shall be or say any wo krata no it shall be admitted into what the objection ni to or the Odo Broni lawyer no objection ni to say krata no enti exhibit B and B1 no ye purported marriage certificate no mo translate enti omo translate ye eba brofo kasem say the be judge ni betimi aka enti na nkofo kasem na judge ni tiase na judge ni tiase o translate and authenticate ye translation ni authentication they are two different things in na in translation say they make country ni brofo me dane no may translate na say obe authenticated there is to give validity no validity is to give validity to krata so what I say nti yo sa no na judge no wo person worker nti wo ye no say nti mene I nti o say then also purported the original that was brought before by the court for the court to compare the plaintiff to said the omode ba ye no say court na nya de nsusu ho nti no ni chese ni nsam keka ni nyina ni say han wofa ni say certificate na ba na foreign document a be foreign signature nse honom na maka nti ni say nti no ka waso ono de court ne kan wa ha wo say nti nke waso wo mu frɛ obi waso mu frɛ obi ma ne beka safa ho to hu se wo keka asasem na say nke waso mu frɛ obi e ma ne beka nke waso mu be frɛ e honom no ye beka asem bi wo ho about discretion of what can be about discretion. The next way, you can't say about discretion. We'll talk about it. Until even though the court is not bound, until import the expert witness by no just all the expert witness by assembly expert witness no can be an court in Nigeria to there be sanity name no expert witness no will be as persuasive as possible. However, the court to now expert witness assembly to one. I was a court to try the currency and one expert witness na anyede asem wanto ahaso so yehun expert witness bia anyede amba nti no woji tum nti owie no osabeka say these required provisions were not adhered to by the plaintiff osani amawe was section 161 no section 136 no ni aya keken nyina no ma me Akosua Serwaa omo endi so e wo mrem mesrew mrem omo endi so nti no see they were not adhered to. Now, was also cutting say the page 18 of the written address by Akosua Serwaa lawyer no. The council did not only admit what you to say or more authenticated documents no. Lawyer na nkasa di to say or more authenticated documents after injunction in October. lawyer na asa agi to mu ha say o ma authenticate document na mo modin chire mu ka ho say na emu edin na edin ma no say o mo beye esan say na emre ne niam kakanta say it was practically or say that are practical hardship. That is what stress and your bay na emu edin ma no say o mo be meet the demands no of section 161 no and was in name no or more trust was in name was and yet in answer to interrogatories into interrogatories near questions be a woody kai answer and sana just say you started trial and say baby jada kemuni ebu asem ni busa wa no no yi asem na no na ha ti sa interrogatories na sa questions na court no omu yi ano no Odo Broni and sorry Akosua say wa amu yi ano answer no mo dey ban or say the first question was answered to show say the document na omo dey ban your authentic marriage certificate. See the first answer no was it was answered to show say it was an authentic marriage certificate. The counselor of Ghana mission was Germany. Tachi me wa na ntesa. O ha o nyam na make on. Nyam na make. So nyam na make or say which was not the case. No, so say this interrogatory nti ho no kan clerk na sem no ka ba mo say dem mote wa happy so. Nti ho no dey interest so. Nti o say sim ho ni nyina ho nsem ni na me pese. But sansem no wo Hana Clark na sem no page 27 year dream Hana Clark na sem ni nyina aye de ewo nti no sa kwade nyina TDC ye so say it must state that there is a distinction between the legal burden of proof and evidential burden of proof me catch am say marane de enye se ne open no na se ne marane tem sa to say legal burden of proof ni evidential burden of proof no say when it comes to the legal burden of proof anyone who makes an assertion bore the burden into say about legal burden of proof. I say when I will say okay some maka so when I will say when I was say chire ni o mu say you 2 million na chire si na my bube no enti no sa na ha no ye pese ye chire sa na ha ne ye chire na sa soon as about when it comes to the evidential burden of proof it is like it's also a tactical because evidence no ubetimi akura pa so ye nyintu esan say woni ema e wo say wo ye ma wo evidence ye dim na wo krata edim into was here party is to produce evidence that is to support an assertion tell was a woman evidence e be boa wasem ana say e be bre nipa na woni na etwema nso na e be bre ono na asem ayede ase e hono no state the controversial case of Akosua Baumia and Obeche Belamte versus Mahama and Electoral Commission okay special edition case state e no wa ha ti ori e no say let me state that the plaintiff should have attempted to certify I think I was say omu tu anamon say womu certify kratana tu anamon say wo certify kratana tu anamon say wo certify kratana na mpo fa letter na wo de akoma embassy no Ghana embassy wo Germany no fa say no ka ho say ye tu sa anamon no enu mpo ka be kire bibi yenso ni nyina no anye dey amanisa therefore ma kwa ba yenso aso o say authentication asema ya kan o say authentication no amasoa any certification no amasoa okay na mom na was a lawyer no for Akosua Serwaa no na was what the original certificate no back court because what can say wo see the court was informed na make o Mrs. Mameka na make o so the court was informed that there was an original certificate. However, what was brought to the court was an extract from a family book into no sa original certificate na court any that to say o mo de baba no na emu extract na say copy bia ye koyi free family book German for a family book mo no e ho na o mo de baaye na eno so no lawyer for Akosua Serwaa ejitumu e wo open court say extract na emu enyo original certificate. The document therefore could not be the original and its copy being exhibit B nti exhibits no mo de baaye no o say ne say ni nti sa extract no na ono won't mean consider ne say your original copy eno de yenyina ye ne ya adwe say extract is extract original copy is original copy nti ori no say therefore the extract cannot be a proof of a civil marriage ne say nti extract na am the free family book no enti me nya evidence supporting a civil marriage between the mama Akosua Serwaa and that Lumba nti the extract is significantly different from the evidence no mo twere wakrata so say eno no mo dey buy marriage certificate no two different things ne santi court no entimi engine na owie ye no to as same patch you will pay 29 sorry you will pay 39 enti ha no owie no say ne sa so e na extract a free a foreign document esa be foreign signature said you odi kan ye no specifically no Evidence Act no section 161 no ama conditions bi e wo se we de wudi so enti when this wa entimi Emma yenje krata no foreign krata na ntum e ho no about the case of Hussein versus Eba Supra na Odo Broni lawyer no aboso o say team so say sene omukura wo sa case ni mu o kura ne saa e wa asem yesuso emu nti e ho no mo no o ka say exhibit B na wo mo de ba ye no e wo se nkenya authentication no any the civil marriage certification ni nyina e free Bonham marriage registry e wo Germany no esan say mmra no e undertake senka e wo se saa de na ye den e baso nti amaso no wo no ontimi nya ho hwe. There is nothing before the court ade bia wo de hwe ni court na nimu e wo se court ni ye den e consider no wie na okọ ye ma me honesty na fosu so a statement so no so wo ka say na Odo Akosua Serwaa ene ye papa da Lumba e ware wo Germany no wo ho na emum cross examination no omo kusa no cross examination ne say ohun so omo signing was she there when they were signing the marriage certificate? She asserted that I was there. Kase no wo no mo sign emi na pay was it the paragraph 8 of your own witness statement no you claim that the only person wey yan say bisa ye mame Ernestina Fosu who witnessed the marriage was Georgina and not you. That is where the can one witness statement mu say ye mame Georgina na ogina mu ascertain no e mame Akosua Serwaa no pe e na ehun so mu mienu ware na enyo no nti ade nti na afi de wo ka that is almost start punchy holes for witness statement so there emu no say dabi me nua be ma no o say e de me ene Georgina ene call the same day so we were living with them in Germany. That is no wo oji tu enti no omu busa ne say nti woni me ya adwen say na wo nua be ma no ne e mame Akosua Serwaa sign certificate no ono ka say ha no na what you me there is say once they were married they will sign a certificate which means one share there or as you say anyway yeah also hu ya hu ento aso enti Mera Dorinda say answers na e mame Ernestina ma no clear say marriage certificate must have the signatures of the couple because also mummy no sign. And if not, the mere reason for an expert witness should have been brought by the plaintiff. Or say mummy no a signature ni ehun expert witness na sem ne de. Ko say wa mutimi at least or mutimi ye den. E de ba. O say nke be speaking to the prominent features of a valid marriage certificate. As I say, entino or say munhwe or say then a look at exhibit 0 series is supposed to be that the Lumba and the plaintiff signing a document. It can be any document. It grab a okay, or say signing a document. Or say if the evidence is true, then a marriage certificate bearing the signatures of the parties should have been submitted. See some of the picture about wumi no sign krata bi dia. Any anka what's a certificate no. You must wumi no omu signature ye den. E wo so. Sa no work am. Nti eno nti no. Won say wumi no signature ni so. Signature na wo so ne ye German official bi so ono so so anya de won ti ase. Sa na ma ni nyina. So see in the alternative, the absence of such signatures on the marriage certificate from Germany should have been affirmed by the expert witness. But since mudia mo enya mudia mu mienu signature no so kora nka mo ma me expert witness e. Mama me no sube. So we no se Ghana aware krata no. Ube hu signatures of the couple. Wa ware wo mbre mu abe hu se wo be sign. Ura be sign and we yere be sign. If the court is presuming German law to be the same as Ghana law, then it's a court na ifa Ghana German mrate said ye Ghana mrade. And en ko se ye hu omumi no omu signature so what I say but ni nyina no ni omu de ba ye no ye hu bibia sa explanation bia so nim enti it is more the reason that the document should have been authenticated because me no certificate ni so enti no kura sa na e nyina enti no cause at least munya authentication kakra na mutimi de boa ye and the signature identified and certified as required by it's still our Sujina certification no so page 13 yedri or that is authentication as a serious matter. Into the same document is attached. The same document is seen attached to SBC being the letter allegedly written from German embassy. The last paragraph SBC says attached you find a copy of the said marriage certificate for your perusal. Now hono no say omo de krata bi fi German embassy by say adna eno na omo trust awase No, sister, krata no mo de buy no. It's supposed to be the same document as Exhibit B, but it has a different signature and a date. The document is signed by G. Stans Bemeter, a German date. And now my date no 23rd October 2025. 23rd October 2025. Or say any not just Exhibit B no. I supposed marriage certificate no so no. Has the signature of another Bertram. And Bertram stands beat him. Hey, do you know the Biamtino said they dated 12 August 2025. Or see, the two documents look similar with similar information, but there is no explanation as to why a different signature needed. Honey, dear, just told me say, Judge, no, more confusing, See, you say the court has not been given any explanation as to why Exhibit B, is seen. Or say is at the current Exhibit B, and Exhibit C, so because as to what exactly which one was brought as the original or said to be an extract, even if it is the marriage certificate, same cannot be relied on by the court as they were not authenticated. And now, Omunina so contrary to section 136 and 161 now. Ya boss no. Me that's I say more.